recommendation made or decision taken by the public servant should be in discharge of his official functions or duties, and the previous approval of the authority is mentioned therein. My lord, in fact, in B.S. Yedurupa's case, my lord, case of denotification, the division bench of this court, my lord, in para 31, I've just quoted that as said, even otherwise, the order of denotification passed by the petitioner, in this case, it's not passed by the petitioner, para page 31, in the circumstances discussed above, cannot be construed as any recommendation made or decision taken by the petitioner in discharge of his official duty so as to attract section 17A of the PC Act. So, my lord,
Yes.
this is, and next, my lord, even the Gujarat High Court also has held on identical. The word relatable is an adjective. The legislature in this wisdom has used adjective relatable to connect the offense to a recommendation made or decision made. Therefore, such approval shall be required when the offense is associated with and connected to a decision taken or recommendation made by a public servant in discharge of his official duty or function. Use of the adjective relatable to the offense is considered opinion of this court, limits and restricts the offense to be associated with and connected to a decision taken or a recommendation made by the public servant in discharge of the official duty or function, and therefore can't be extended to all offenses under the PC Act. The same is Madhya Pradesh High Court, para 6.3. Section 17A is attracted only when the offense alleged under Section PC Act relates to the act of recommendation made or decision made, but is not attracted when the offense relates to demand or acceptance of bribe, taking to an illegal gratification or disproportionate.
No, that's why trap cases gate is not applicable.
Please, my lord. Then last, this Kerala High Court judgment, my lord. Ultimately, my lord, that is why the SOP becomes very, very important, my lord. The checklist gives for the purpose of formation of opinion, para 9. The most crucial part of Section 17A provides that the previous approval is required in relation to an inquiry or investigation into an offense alleged to have been committed by a public servant under this Act, where the alleged offense is relatable to any recommendation made or decision taken by the public servant. It seems that the above part of the section is most crucial part of the section, since imposes a rider that otherwise the absolute power under Section 17A, so and so, so and so and so and so, in every act needed prior approval.
Yes.
My lord, next one other aspect, my lord, if your lordships kindly turn to page number 13, my lord. This is with regard to Yashwant Sinha versus CBI, with regard to preliminary inquiry, my lord. Just going back.
3.
Page 13, my lord.
Yes. Sirajuddin is followed.
Sirajuddin is followed, Yashwant Sinha and Prabhat Kumar Dubey, my lord. The reason I'm using the preliminary inquiry, my lord, preliminary inquiry has to be, so even in case of Sri Rupa, my lord, what the courts have said that while doing the investigation officer should have credible evidence based on which an opinion is formed by him for the purpose of seeking of prior approval under 17A.
Yes.
So therefore, my lord, in this case, my lord, I mean,
According to you, the petitioner has not done anything that is relatable to a decision taken or a recommendation made.
I'll slightly modify it. What is not there in this is, my lord, it is only an investigating officer who can give.
No, I'm only asking a simple question.
Please, my lord.
According to you, the petitioner has not done anything that is relatable to it. Sir, petition. You're appearing for the complainant?
No, your lordships are saying petitioner
No.
is accused.
Petitioner is accused. That is what I'm saying. According to you, you are for the government, right?
Please.
Now, your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please. No, your lordship.
No.
No, I'm not on that. That's the legal position, my lord. In order to invoke 17A, that is a condition precedent, my lord. As your lordship pointed out. Here, I'm slightly one step further to entertain an application, my lord, under 17A. There should have been a preliminary inquiry.
That I understood.
Please.
What you're saying is even for an application seeking prior approval under 17A, there should be a preliminary inquiry
Inquiry.
as is necessary in Lalit Kumari and the SOP that is by the Government of India. That's your submission. So here there is no preliminary inquiry and the competent authority himself has now acted instead of referring it to the police for preliminary inquiry as an approving authority conducting inquiry himself and passing an order. That is your submission.
Second submission. And the third is, Manoj, what your lordship felt, if the petitioner decision or recommendation and holding the post. So these are the three requirements, Manoj. If I may read section 17A, so what is required is relative recommendation, decision by the public servant. Third, most important, in discharge of his official.
Correct. That is the
therefore-
soul of the, see, that is the soul of 17A.
17.
In discharge of his official duty, if there is anything recommended or any decision taken, this can be set into motion. That is the purport of 17.
And your lordships have said, what is the object and purpose also of 17A
Yes,
is to
sir.
protect the thing. And why it should not be abused also, your lordships have dealt in Dr. Ashok and Pradeep Kumar
All,
in all those cases.
all right.
Keeping those in mind, Manoj, the question, what your lordships lordships will decide is, Manoj, not only in this case, any other, I mean, on a principle of law, Manoj, a trigger-happy complaints are filed day in, day out against various public servants to the competent authority, Manoj. Then the nature of inquiry, again, which ought to have been done, hearing the complainant, hearing the accused, then a decision being taken, Manoj, that will send a very bad precedent or a proposition of law insofar as granting prior approval for investigation, Manoj. It will defeat the purpose of section 17A. So therefore, investigating officer has to be only an police person, Manoj.
Oh, you are coming at that.
I've been trying to come at that. Manoj.
Yes. All right. Yes.
So therefore, my lords, ultimately, unless that report is there, that is what, I mean, that is what they say, the investigating officer forms an opinion. That ultimately, my lords, there may be, ultimately, my lords, it is for the competent authority to decide on the material, to grant or not to grant. He may not be bound by the
Report of the investigator.
investigating. He independently, he gives approval to, therefore, my lords,
Approval for what if there is already a report by the investigating officer?
no, therefore, he may accept it or reject it.
No, approval granted in case he wants to grant approval. For what does it grant approval?
Investigation.
It is already done.
No, he forms an.
You said investigating officer submits his report and seeks approval. For what does he give approval? For investigation again?
Please, Manoj. So therefore, Manoj, that is, I'll just put it. Preliminary inquiry is with regard to cognizance on offense which he formed, the investigating officer forms in view of the bar under 17A. He has to seek permission from the competent authority and the competent appropriate gives approval to that. So without the approval, he can't investigate. That is why he seeks the approval.
You're trying to blow hot and cold. Now, prior to approval, you said there should be some inquiry or some report prepared.
That is what Lalit Kumar has said.
That makes sense. You're hinting upon Lalit Kumari's principles.
Principle. And Manoj, your lordship, the lordship circular also may be kindly seen, Manoj.
Lordship circular, High Court circular.
Your pursuant to your lordship's
Order,
pursuant to your
Ashok, yes.
lordship judgment
Page-
in Dr.
Page, Dr.
Ashok's-
V. Ashok or something, yes.
Please, Manoj.
Page,
is-
sir.
That is at page number, Manoj, volume 1.
Citation, madam. Volume 1. It's put in.
Page 260.
260.
In fact, Manoj, what you're keeping in mind, the object of 17A, Manoj, what your lordship said, if
60.
260, volume 1.
1 second. Sir. Of the
Petitioner's volume.
petitioner's paper.
I'm sorry. I took it for granted that your lordships know all the page number, but I need not.
No, ಯಾವ volume ಅಂತ ಹೇಳಿದ್ರೆ volume also I should know. 1 minute. Because that SOP you said was last 3 pages of that paper book.
So
That's why.
easy to remember.
ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ಅಂತ. Yes, sir. Page 260.
First, it refers to Priyanka Srivastava, Manoj.
And Yashwant Sinha later.
Uh, Please, Manoj.
Yes.
That is affidavit 173-1 and 173-4. I'll come to that, Manoj. Here, page 261, Manoj. The language, what your lordships has said at page 261 is, Manoj,
Hmm.
even if not to entertain such complaint if they do not comply with the following.
Hmm.
That is, Manoj, one is registration of the complaint,
Hmm.
then prior approval
Hmm.
in case of a prior complaint. Then last paragraph, Manoj, these directions become necessary in the light of the fact that once the matter is referred for investigation, the police will have no choice but to register the crime. Therefore, such approval being appended to the private complaint is signed for maintainability of the complaint, except in cases where concerning disproportionate, which your lordship gave as an excess, such complaint shall bear the scrutiny so and so. So therefore, my lord, pre-requirement is compliance of 154, 173, then 17A. So therefore, my lord, again, my lord, here comes back to Lalit Kumari once again, my lord, because it has, there is no application of mind or not application of mind, no preliminary inquiry, I put it, the language used by the Supreme Court, my lord, no preliminary inquiry done in this matter, my lord. And coming back to insofar as 154 and 173, your lordship may kindly see on the 3 volumes were given by the counsel for the governor, the Solicitor General, my lord.
Hmm.
If your lordship sees, my lord, on those volumes, there is no complaint is given by respondent number 3. Respondent number 3 on 18th July and 25th July, my lord. And the immediately next day,
26th July.
26th July, immediately next day, prior approval is sought. So therefore, my lord,
Hmm.
the-
Prior approval is sought and show cause notice is issued.
no,
on
the
26th.
points I'm trying to make here is, my lord, the question is,
No preliminary inquiry.
so therefore, he had not given an opportunity to conduct that inquiry. If he had given, we don't know whether the police officer themselves might have or might not have sought for prior up.
No, if your submission is accepted, that permission was not given up to
Time.
sufficient time or whatever. 17A ಆದ್ಮೇಲೆ ಅದೇ ಆಗದು.
No, that's a different aspect, my lord. No, just because it's going to happen after 17A. the
Just
court-
because, not just because, only because.
No, only because, my lord, your lordship, go by to the Supreme Court judgment and the judgments of your lordships and the SOP cannot given a go by because it is likely to, the scope of that is entirely different, my lord. Once the complaint, 156.3, that's entirely scope. I'm not on.
No, if you are hinting on some inquiry, investigation should happen. Now, if the impugned order, I mean, like, by the impugned order, what is done is that only.
That he could not have done. That's the whole point, my lord. He is a competent authority, not a preliminary inquiring officer.
All right, yes,
That is what is prohibited in law.
all right.
Sum and substances. So therefore, in fact, para 3 and para 9 of the written submission says, we have done preliminary inquiry. We have not done, given prior approval. Your lordship may kindly see the written submission given by them,
By whom?
the Solicitor General, my lords.
Kodi?
All they say that we have done a preliminary inquiry as required in Lalit Kumari.
That is prior to giving approval.
By the competent authority.
By the, prior to giving approval.
By the authority,
So
which,
according to you, police officer should do that.
that's what the law says. Your lordship, that is the requirement, my lords. So therefore, the application of,
Sir, 2 things.
please,
If the crime is registered before the police, now if it, or the lokaयुक्त or whatever it is, if it is touching upon or an amalgam of offense under the Prevention of Corruption Act and the IPC, prior approval will have to be sought.
correct.
All right. The police officer or whoever files a prior approval before the competent authority to inquire or investigate. Permission comes, then he starts investigation.
Correct.
Starts investigation by what? By registration of a crime. All right. Now it is a private complaint. Straight away, a private complainant goes before the court. He seeks reference under 156(3), now under 175 of the BNSS. Now, if the matter is straight away referred, now say, it is.
Your Lordship says it's not permissible.
No, that's what I'm telling you. If the matter is straight away referred for investigation to any authority, to jurisdiction, police or to XYZ, no choice but to register the crime.
Correct.
So what happens to 17A?
So therefore, what,
By way of a private complaint, you get, obviate the process under section 17A and straight away get a crime registered, where 17A, if it is before the police station or before the officer in charge of a particular police station, be it the Lokaयुcta, 17A would be required. All right.
Correct.
Now, 17A, the approval is sought before the competent authority. Here, the competent authority is the governor. Governor initiates certain process, not that day it is granted or what day it is granted. How it has been granted?
I'm
we'll
not on
answer.
that, my lord.
Yes. So according to you, Lalit Kumari had to be followed, preliminary inquiry had to be conducted. Now, in the written submissions, the learned SG says that preliminary inquiry is conducted
By the,
as contemplated under Lalit Kumari by the competent authority.
which is not permissible.
That is your submission.
Is virtually impermissible. He does not act as a investigating officer under law. He only is a approving authority, what is sought by the investigating officer. That's the summon. And all he, and what the whole case and the record shows that 25th was the complaint, 26th, the file movement, he was heard, show cause notice issued, and reply sought for, and a decision is taken, clarification sought from the complainant, and then a decision is taken, which according to them is a preliminary inquiry is what they have done. Can I read para 3, Malad? It is of the written submissions.
Yes, sir. Page?
Page 9, para 3.
Ah.
It is submitted that the stage of granting approval under 17A of the Prevention and Corruption Act, it is not a stage where claims and counterclaims have to be weighed or weight of the allegation is to be tested. It is submitted the only test that ought to have been adopted is whether there is an allegation which discloses the commission of a cognizable offense and apprehension exists that offense may have taken place, requiring an investigation to be conducted in accordance
Yes.
with law. Para 9, can I request, Malad?
Yes, yes.
That is at page number 12.
Hmm.
It is submitted the order to further understand the scope of inquiry at the stage of approval for investigation. The principles laid down in the case of Lalit Kumari versus so-and-so, the Honorable Supreme Court ought to be referred to. In the case, the Honorable Supreme clearly held that once the cognitive offense is disclosed in a complaint, the FIR must necessarily follow. The said principle was laid down in the light of statutory provision and so-and-so, and the understanding that the FIR is merely the starting point of a lawful means to uncover the truth of the matter. So the point here is, my lord, who has to do this preliminary inquiry? It's not in dispute according to them also, my lord, that preliminary inquiry need not be done. According to them also it has to be done. It says, I will do the preliminary inquiry. So therefore, my lords, there is no doubt that preliminary inquiry has to be done, even according to them. Then, my lords, page 14. Para 10.
All right.
I'm sorry.
Yes. No. For whatever is to be done, preliminary or otherwise, 70.
Please, my sister.
Right. Yes.
My lords, what my submission is preliminary, as your lordship in the initial start, preliminary inquiry cannot be read into 17A.
All right. We'll consider. Yes.
Para 10, it is submitted that for the approval of investigation must be exercised guided by law laid down by the Honorable Supreme Court. It submitted in the case of information given to the police discloses the commission of a cognizable offense. The approval for investigation is to be granted unless the allegation appears to be wholly biased, motivated, and false. In furtherance of the aforesaid, it is submitted that the intent of the Honorable Governor was to ensure that proper investigation is conducted in the present matter to merely uncover the truth in the matter and to not to take any specific sides.
According to you, according to them, preliminary inquiry is conducted by the competent authority.
Please. ultimately what they said, we have followed Lalit Kumari. Then one of the important aspects, my lords, with regard to your lordships, have held in Dr. Ashok's case also, my lord. In this case, my lords, insofar as respondent number 3 is concerned, my lords, as I pointed out, complaint is given, not even 24 hours is what was ordered to be waited for before approaching the governor on the 26th. Immediately, my lords, he is heard on the same day. That is one aspect of the matter, my lords. Whether you could have heard
After a few days.
No, not after, whether it could have been heard at all. At all. And what was thought to be argued, like the procedure need not have been followed. The question is, there's no such procedure. Rightly, my lord, there's no such procedure to hear a private citizen or a complaint. My lord, especially, my lord, when at the cost, allegations is made against an accused, whoever that may be, my lord, without his presence. And subsequently, my lord, issuing show cause notice, the whole procedure is not contemplated in the eye of law at all. When that being the case, my lord, the question, what your lordships will consider whether application of mind, principle of natural justice, reason order, I don't want to go into those aspects.
So you are at the root.
The root
It cuts at the root.
Because the third, fourth, and the fifth complaint, my lords, here also I am not sought to give follow the requirement of section 154 or 173, my lords. If your lordship may kindly take the few dates in the written submission, my lords. Your lordship may kindly page 7, my lords.
Page 7.
Page 6, page 5, I'm sorry, my lords.
Oh, this table.
This table, which is forthcoming from the compilation of documents given from the governor's compilation, my lords. On 18th July is the complaint given to the inspector of police, my lords, Lokayukta.
No, but it was argued that you had tendered an opinion saying that it is, they only have to seek the prior approval at 17A.
No, what, I'll come to my opinion later.
No, that's what I said. Because
no, they have
no,
to.
now you are saying that police officer has to register, police officer has to seek permission.
No, what, they're slightly different what the opinion is given, what I'm submitting. My lord. Here, my lord, if they are complied with 154, my lords, as I submitted earlier, he would have done a preliminary inquiry, then sought, as your lordship just pointed out, my lord, he would have, if it's a cognizable offense, he would have sought for a prior approval under 17A. The question is, my lord, whether 154 or 173 was sought to be complied. My lord, this 154 argument comes when private complaint is filed. But what my submission here is, my lords, the entertainment of the competent authority ought to have seen whether that procedure is followed prior to entertaining an application under 17A, my lord. The reason is this, my lord. If that was not followed, you should have seen that such a procedure is followed so that that material was with him. Here, my lord, 154.1 is not followed, or 173.1 or 173.3.4 also is not sought to be.
151.
152,
1 and 3.
1 and 3 has not been.
151.
Please, ma'am. So therefore, my lord, to entertain that application also, application 17A, my lord, this crucial aspect, whether the compliance of 154, my lord, was done, or 173, 1 and 4 was done, was very crucial. If that was not done, my lord, it ought to have been returned back, saying that comply with the said procedure, then you file an application. And in fact, insofar as Pradeep Kumar is concerned, my lord, that is respondent number 5, no such complaint is given at all. And insofar as respondent number 4 is concerned, my lord, application is filed subsequent to filing a complaint before the competent authority. and the competent authority has considered the application dated 5th July 2024, which pertains not seeking prior approval, but seeking CBI inquiry. So therefore, my lords, insofar as application of respondent number 4 for grant of sanction was not there, neither in the file of the competent authority, the Honorable Governor, my lords, or in the statement of objection. So therefore, my lords, the application sought for ought to not been entertained on this count also.
Yes.
Then finally, my lords, one of the point coming to now the aid and advice, my lords,
163.
163.
Hmm.
Insofar as courts, MP police establishment, and they've all said, my lord, the discretion is with the
Governor.
governor. The question is, what is this discretion? How he has to exercise this discretion? For example, my lords,
Hmm.
on the basis of if the aid and advice or there is material, we'll take a situation, my lords, where recommendation is given grant, the aid and advice is to grant sanction,
Hmm.
and the same is rejected. It can work both ways. In this case, my lord, the advice is not to grant sanction, it has been granted. There may be cases, my lords, where recommendation is to the other.
Not to grant sanction, but sanction is, but sanction is to grant sanction, sanction is not granted.
Not granted.
All right.
So therefore, my lord, this discretion is not his absolute power or absolute discretion which he can exercise. This is limited to what has been held by the Supreme Court in MP Police and Justice Punchi's judgment and Nawab Rabia and all these judgments. Ultimately, I just like to write 2 paragraphs of the judgments, my lords. My lordship may kindly take to page number, my lords.
48.
Please. Page 41 for a moment, my lords.
The discretion begins there. Your
Uh,
submission is at page 48.
Okay. Note on points with regard to.
Yes.
So therefore, my lords, with regard to limited discretion, narrow scope of discretion, reason and caution, my lords, keeping that in aside, my lords, I'll just, where is that paragraph? Your lordship may kindly turn to page 55, my lords. At point number 4.
MP Police.
Which has been reiterated in AG
Yes.
paragraph 4, my lord. It is pertinent to note, as evident from the impugned order and the materials put forth by the governor, there has been assumption of bias contrary to the legal principle established in MP police establishment, Nawab Rabia, and so on and so on. So the exception carved out in this landmark judgment for when a governor may act against the advice of the Council of Ministers have not been addressed or satisfied in the present case. The impugned order and the material produced by the Honorable Governor fails to provide any substantive reasons from deviating from the aid and advice given by the Councils of Ministers, nor does it demonstrate how the Cabinet's recommendation against granting sanction was irrational or unsupported by material evidence or suffered from bias. Furthermore, the order lacks a reasoned explanation to establish its own rationality or to show that it is based on through consideration of relevant materials. This absence of reasoning, coupled with apparent haste in the decision making, raise serious question how the propriety and legality of the impugned order protection infringes upon the constitutional scheme and governance principle of federalism.
Yes.
Your Lordship may turn to page 43, my lords, for a moment.
Hmm. Yes. Sir.
The 43 last paragraph, my lords, 4.2.15
Yes.
explains, referring to Shamsher Singh and M.M. Punchi's commission's report, my lords. It's just been culled out over there,
Yes.
which page 43 highlighted portion, my lord. Thus, the scope of discretionary power as provided in exception to clause 1 and in clause 2 of article 163 has been limited by clear language of 2 clauses. It is an accepted principle that in a parliamentary democracy, with a responsible form of government, the power of the governor as a constitutional or formal head of the state should not be enlarged at the cost of real executive with the council of ministers. The scope of discretionary power has to be strictly construed, effectively dispelling the apprehension, if any, that the area of excessive discretion covers all or any of the function to be exercised by the governor under the constitution. In other words, Article 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. This area of exercise of his discretion is limited. Even this limited area, his choice of action should not be arbitrary or fanciful. It must be choice dictated by person, actuated by good faith and tempered by caution. So
Prudence, caution, all right.
So, Malot, this is the, so therefore, Malot, the Lordships will see, Malot, whether the impugned order comes within the four walls of this aspect. So therefore, Malot, the reasoning that the impugned order says it is my discretionary because there is bias apparent and evident is not a ground. As already pointed out, Malot, it should be by reasons with which the reasons should be in the order itself, not in the file, Malot. I would just like to take your lordship to the file for a moment, Malot.
Which file?
The governor's
Oh,
file.
all right.
Just I'll end with that, Malot. Just want to point out 2-3 aspects
Yes.
in that, Malot.
Madam, ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ
Volume
ಇಟ್ಸ್ ಇನ್ ವಾಲ್ಯೂಮ್
1,
ದಟ್ಸ್ ದಿ ಆರ್ಡರ್
the order sheet,
ಆಲ್
proceeding.
ಎಸ್
If
ಪೇಜ್
page, Malot, page 1, Malot.
ah
If your lordship sees, Malot, reference subject is sanction for prosecution, Malot, of so and so. Petition, so and so, dated 26/7. Kindly produce petition by so and so, serial number 1.
hmm.
Then next page number 2, Malot.
Hmm.
Please pursue papers, pre-paras, the complaint addendum. Then next at page 3 on right on top, Malot.
Hmm.
I have heard so and so in person and gone through the petition and supporting documents submitted by him.
Hmm.
Prima facie, I am of the view there might be irregularities and misuse of power.
Hmm.
Hence, show cause notice to so and so within 7 days.
Hmm.
So this is what the preliminary inquiry sought to be done, Malot.
Hmm.
Then can I request, Malot, page 7. Speaks about, Malot, the reply given by the petitioner, then the proceedings. Then last at para 20, Malot, put up along with the comparative statements of petition, chief minister's reply and cabinet decision.
Hmm.
Then at page 8, Malot, as directed at para 20, comparative statement of petitioners received so and so, so and so, so and so, reply are placed in the file for kind perusal. Perusal file discuss the issues, hence resubmit, kind notes, points dictated. Then this is page 9, para 25 is important, Malot.
Hmm.
Insofar as TJ Abraham, Malot, what is taken note of is the 26th July.
Hmm.
Insofar as Pradeep Kumar Malot is 14/8 and Malot Nehemiah Krishna is 5/7, Malot. 5/7 pertains to referring the matter to CBI, not the additional memo which has thought to be filed on court. So therefore, Malot, of law, Malot. In fact, your lordship's judgment in Ashok and Pradeep Kumar all says the reason should be in that order itself, Malot, because it is a 17A is a protection given to the public servant. The files or the notings in the
File notings will not supplant
supplant
what is not there in the order
What is
or
there.
supplement what
Sup-
is there in the order.
order.
Not
So
supplant.
therefore, to say, my lords, I did A, B, C, D, E, F, G, but my order may be wrong. But look at A, B, C, D, E, F, G. Ultimately, my lords, what is looked into is the order. If the order is bad, it's bad. So don't try to, as your lordship says, supplant the file to look into the order. If the order does not satisfy 17A, my lord, the order has to
Go.
go.
Yes.
So therefore, my lords, insofar as this legal, because these submissions are made on what the, therefore,
So, understand? Any other submission?
that's it.
Your synopsis, your written submission also is the same?
Same, my lords, on the same line.
Why you have stated position of the governor under Article 163?
No, not this governor, generally governor.
No, either. Point 3 at page 656.
This,
56 of your written submission.
my lords, this is a
Nothing.
federal structure, well, not insofar as this impugned order I'm talking about.
In general,
In general, man. I'm not dealt with the impugned order in specific at all.
Constituent Assembly debates. Article 143 there.
Please. In fact, my lord, the discussion, I've enclosed those copies all over discussion, my lord. Ultimately, my lord, as your lordship, the discretion is there to what extent, it all depends upon facts of each case, my lord, which your lordship will consider.
Yes, sir.
I'm
Anybody
grateful to my
else?
lords.
Anybody else? Imdidia, sir.
I'll make my submissions after Dr. Singhvi.
Yes.
Dr. Singhvi
But
is on.
I will be doing it on 12th, Palas. I will do it on 12th
12th, sir. Yes, we'll finish it on 12th.
unless my review
The
petition succeeds.
complainants have all completed?
Yes.
Yeah. They completed last.
You have submissions to make? No?
Reply to reply.
After the
Reply to reply.
reply by Dr. Singhvi, sir. All right.
Palas, after my reply,
Again, it will
Palas,
go on then.
normally-
This
no,
rejoinder,
after my reply, I
adella.
am a rejoinder, Palas. I will be doing a rejoinder. There can't be a
One minute,
reply
one minute.
after
Yes,
that.
sir.
Palas, after I reply, I had opened the matter, Palas. It has to be, if somebody argues after me, Palas, then I will need a reply to that also. No,
Then it will
except
go
my
on.
learned friend. No,
See,
except my learned friend on my
Whatever you
side.
want to reply, file by way of reply, and you want to any clarifications later, you submit on that day because you have not submitted at all. And sir, also, if you want 5 minutes, that's all.
No,
Oh, sir.
no, ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Huh?
ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕೆಸರ ಗ್ರಾಮನ. I have to show it to the court. It is not.
No, my learned friend can.
No, he's sailing with you, sir.
No, I thought it's somebody else, fellas. I thought I
No,
didn't see his face.
Dr.
He can
Singhvi,
argue after me.
No. I said I'll make my arguments after you complete your arguments.
No problem. He's on the same side.
Yes, that is
I
what
thought
is.
it's somebody else arguing.
No.
It is.
I'm only going to supplement what you make, what you
that's not
submit.
right. I misunderstood.
Without repeating
I
what
thought-
you said.
I thought it's somebody else. I'm sorry.
No,
So, ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 464 ಇದೆ. ಅವೆಲ್ಲ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ತೋರಿಸ್ಬೇಕು.
ಇರೋದನ್ನ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ನುಂಗಿಲ್ಲ. ಈಗ ಹೇಳಿದ್ರಲ್ಲ, ಗ್ರಾಮನೇ ಇಲ್ಲ, ಜಮೀನೇ ಇಲ್ಲ. I'll show. Where is the village? Where is the? I'll show.
All right.
Okay.
So this will go on and on. I am not.
No. I'm only going to reply. No, sorry. I am going
Right,
to
1 minute.
reply.
Sir. 1 minute, 1 minute. The right of reply is always there. You have submitted, right of rejoinder submissions is always there. If any clarification to that, yes, you can't go on and on like this and it becomes a circle, sir.
Whole day it was argued saying that Kesara Grama is not there.
No,
I will
1
show
minute,
where
sir.
is Kesara
1 minute. For whatever you have submitted, they have a right to reply, they will reply. Then after that, it's not that you have a right to reply. It's not like sir rejoinder, filing sir rejoinder, sir submissions here.
Reply to reply is unknown, sir. Unknown.
But they will, sir, 1 minute.
I don't know why my
You
learned
have
friend
made
is-
some submissions. They have a right to rebut, 1 minute, rebut those submissions. If it is by way of new things, what can be done?
No, I don't
In
know. why-
justification, they will say whatever is there. Allah, I can grant time, that's not a thing, but it will go on. How long do you argue the same thing?
So 12th, fellas. 12th.
New proposition, where are the new propositions, sir? You have submitted the whole day on 31st from 10:30 to 4:45. We'll see. You also want to clarify?
With respect to the chief minister's role that is, your lordship.
All right, let Dr. Singhvi Saab finish it. We'll see. Yes. 15 minutes. No. We'll see. First, let the respondents finish. Avate ಮಾಡ್ತೀರಾ sir ನೀವು?
Petitioners, yeah. ಅಲ್ಲ,
Petitioners.
ಅವರು ಡಾಕ್ಟರ್ ಸಿಂಘ್ವಿ ಮುಗಿಸಿದ
The
ಮೇಲೆ
moment
I don't
Dr.
want to
Singhvi
repeat.
completes, you-
Yeah, I'll immediately start.
Maharaj, let me just make one thing clear. If anybody has any new point, they should give it to your lordships today or tomorrow. Because if when I'm rounding it
Today,
up,
no new points, sir.
after my finishing, if somebody argues
No,
other than Mr.
just a
Ravi
moment.
Kumar,
Then you submit
be a
whatever
great
you want to
disadvantage.
submit.
That's your lordship.
If you want to say straight about the role, please state. Then Dr. Singhvi Saab will reply to that also.
That's all. Well,
I will hear you. How long will you take?
Then 5 to 10.
That's all. Then you, if you're ready, you state. Yes.
Lordship,
Obliged.
your lordship had put forth rules. What is the role of the chief minister ultimately in this entire matter?
Yes.
Key words are check period. Check period, your lordship. What happens is in all prevention of corruption matters, the date in which the position of power was held by the person, that is critical. Check period is what is taken into account for any irregular accounts that have entered into the person's account or the wife or any other family member. If the check period is gone into, then all of this falls in place. Your lordship, ultimately, we are only looking at when are the periods in which the petitioner held a certain post, and that is the time during which all of this took place. Your lordship, it is only between the year 1996 to 1999. 1996 to 1999,
Deputy Chief
he was the deputy CM. That period, your lordship, is the denotification period. I'm not going to expand further. The 1996 to 1999 is the entire denotification period which took place, and subsequently is the year 1999 to May 1994. That is the period when
2004.
2004, wherein the petitioner was not in power since he had lost his elections. Therefore, your lordship, that period is the lull period. Nothing takes place then. After that is during the period of 2004 to 2007. That denotification portion is over. So therefore, 2004 to 2007, the conversion phase starts. So from 2004 to 2007, documents are already there and they have gone into in length in that. So that is the conversion period. Subsequently, 2008 to 2013, your lordship, this is when this transfer takes place from A4 to A3 to then A2. That happens between up to 2010. Your lordship, between the year 2013 to 18, when he is the chief minister, at that point of time, A2 takes over. The vice gives all the representation stating, give us compensatory land. So the phases of denotification, phases of conversion, and then phases of submissions of representation, and then seeking compensatory lands. Your lordship, the key period that the petitioner seems to state is that all of this took place when they were not in power. Your lordship, what happens is the year 2018 to 22 is critical. 2018 to 2022, the petitioner was very well an MLA. Now, it is not about which political party is in power. It's ultimately, did the individual hold a position of power or not? He held a position of power at that point of time. And at that point of time, what happens is that the 14 sites that are allotted are done at a government guest house, done specifically for that. Your lordship, what happens is A2 doesn't go to the sub-registrar's office when MUDA gives this.
That's permissible in law.
That is permissible under the
For the
Registration
purpose of
Act.
registration of sale deed.
Registration of sale deed, that's permissible under the Act only for the person who's exempted from his presence there.
Disabled.
Disabled is one. There is also a list of people who need not be present at the sub-registrar's office. And that
So
is
you're attributing the connection to power.
absolutely every single act that has taken place has been done on behalf of the petitioner, and that has been established all through. And then subsequently, when actually the year of 2023, when all of this is unfolding, at that point of time, the petitioner says, all right, take my 14 sites, give me 60 crores. And so starting from the period on which we start with denotification, where A4 A1 makes A4 to do all of this. That is, the petitioner asks A4 to do it. Up to the time they say, all right, give me back my money. From then onwards, the role is established. Your Lordship, we have only given a set of judgments which the others haven't, and only those we will mention, Your Lordship. These are only with respect to check period. Check period, Your Lordship,
In a Prevention of Corruption Act case.
in Prevention of Corruption Act cases, Your Lordship,
Yes.
I'll
from
very quickly-
Period A to period B.
period A to period B.
Date of joining service till the date of search.
Absolutely. And in most of the cases, Your Lordship, it is more of disproportionate income, and therefore they calculate the income during the time when he was in power and when he was not in power. In this, there is a
But
slight
how is the
shift.
concept of check period relevant to this, or you're trying to paraphrase that to this?
We are drawing a parallel. In this, there is no money that you could attribute to have entered into at that point of time, but it is directly attributable to the acts that have taken place during that time. Your Lordship, and also with respect to what is the role, all of these judgments, Your Lordship, I will not take Your Lordship into detail, but all of these judgments only state that even if, let us assume that the wife, that is A2, would be probably not working, or would have a source of income, maybe an agricultural source of income, and would file income tax returns. Nevertheless, the courts have held that if the person who is in position of power has purchased certain properties in the name of the wife or in the name of any other family member, it would still ultimately be attributable to them and their role in all of this. Directly, Your Lordship, all of these judgments, Your Lordship, I have,
Paragraphs hakidira?
Your Lordship,
You've
we've put
indicated
it.
the paragraphs of these judgments?
Paragraphs
Yes,
have
yes.
also been mentioned,
Yes,
Your Lordship.
yes.
In Ponuswami's case, Paramasivan's case, Balashankar Lingam's case, then
Yes.
Ponnumudi and Soundararasu, and also Vahidida Jayaraman, Your Lordship.
All right.
All of this directly on the point of when a particular person is in power. And that should probably connect the dots, Your Lordship. That's it.
So that's the link that you're trying to draw.
Absolutely. And to say that I was not in power when all of these 14 sites was allotted, he was definitely in power.
No, not in power is not the submission, but not taken any decision directly or any recommendation made by him. That is the submission.
Your
He was
Lordship-
in power, that they accept, that's a matter of fact.
Please, Your Lordship, anyway, the judgments are clear. We don't need a direct recommendation or any letter from them. If we are able to show the link at that point of time. For example, how I've been able to establish that the time when he was not elected, there's a lull period. But all the times that he's elected, activities have taken place. So that is sufficient. And the question always should be, what is the role of A2, A3, and A4, as opposed to asking what is the role of A1? Because A1 is established very clearly. A2 and A3 and A4 could be at best aiding or abetting. And that is something, it's just a matter of trial. But with respect to A1, it's very clear. That's about it.
All right, yes. Yes, now, Professor Sir, you have heard the council also. Elladakku seri reply on 12th. Singhvi sir?
Yes,
On
Willis.
on 12th, sir.
Yes, 12th, Willis.
12th, we'll take it at 10:30 or at 2:30?
Well, it's not at 10:30, but maybe around 12 or 11:30 or
All
something.
right, we'll take it at
I will
12
come to the court. Yes.
Yes, sir. 12 o'clock.
Yes, Willis. Obliged.
Heard the learned counsel Ellardu Hakpade and counsel Srimati Lakshmi Iyengar appear for which respondent, for the fourth respondent. The respondents have all completed their submissions. The learned advocate general has also completed his submissions for the reply submission of the senior counsel Dr. Abhishek Singhvi and the senior counsel Professor Ravi Verma Kumar list this matter on 12th. 12th, we should be concluding this, sir.
Yes, Willis. Yes. Obliged.
ಏನಾರು ಇದ್ರೆ
Obliged.
5 ನಿಮಿಷ ಅಲ್ಲೇ ನೋ ಡ್ರ್ಯಾಗಿಂಗ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ ಅದೇನ್ 15 ಇಂದ 10ಗೆ ಲೆಟ್ ದೆಮ್ ಫಿನಿಶ್ ಇಟ್ ಫಸ್ಟ್ ಆನ್ ದಟ್ ಡೇ ವಾಟ್ ಡು ಯು ವಾಂಟ್ ಟು ಸೇ ದ ಲೀಗಲ್ ಸಬ್ಮಿಷನ್ ಸರ್ ಮತ್ತೆ ಅವತ್ ನೋಡಿ 12th ಎಸ್ ಮೇಡಮ್ ಲಿಸ್ಟ್ ಆನ್ 12th at 12 p.m. 12:12
The judgment supported.
here, yes.
No, I don't have any more to say.
Yes, sir.
I have done whatever I had.
Yes, yes, sir. Yes.
The judgments which I have given along with the note, Malot, the full judgment copy has been enclosed, Malot.
ಅದಕ್ಕೆ ಇದೆಯಾ?
Allah, separate
Separate
compilation,
ಕೊಟ್ಟಿದ್ದೀರಿ.
separate compilation has been,
There are about 12
Yeah.
compilations of judgments now.
we want
ಬರೀ 2500 page judgments ಕೊಟ್ಟಿದ್ದೀರಾ.
for a 6-page prior approval.
Yes, sir. We'll see. Yes, madam. Yes.
Grateful.
ನಾವು ಅದೇ ಹೇಳೋದು for a 6-page prior approval ಇಷ್ಟಬೇಕಂತ.
Allah.
Now,
Mr.
we-
Raghavan has- Mr.
Please.
Raghavan has come.
role is sort of explained by the senior counsel Lakshmi Iyengar. Now we will reply to that.
I'll do. I'll do. Now, interim order needs to be.
That will be extended.
It took so long
For what?
to explain the role.
That is my investigation. That is my investigation.
Your Lordship, the League of Extraordinary Gentlemen went on a marathon. Ultimately, a lady had to take your Lordship through a 100-meter dash.
Let's see. We'll hear it on 12th. Yes. List the matter on 12th at 12 p.m. We'll start at 12 sharp. Sir will be appearing physically or Singhvi sir?
No, Malad, I will be, I'm coming there physically once. That's why. I'm very
Ah,
grateful.
That's fine. Sir. Yes.
Yes.
Ambarakadi. Thirty minutes. Settlement. Child is there, is it?
In F1, technology moves fast, really fast. That's why they need a technology partner that innovates at the speed of the world's fastest sport. From AR to AI PC to IT infrastructure and services, Lenovo is driving F1 to a faster future for all.
Lenovo.